Good morning, everybody, and welcome to the North Carolina Department of Health and Human Services NCDSS 2021-2022 Child Welfare Policy and Practice Update. We are thrilled to have you all with us here this morning, and we are going to be excited to present you with some new and useful information. As Fat Albert is fond of saying, if you're not careful, you just might learn something before you're done. And so we are going to get started with talking about what our goals are for today's webinar. The goals are twofold. Number one, we would like you to be aware of changes to legislation and policy that have impacted North Carolina child welfare practice between July 1st, 2021 and June 30th, 2022. And number two, we want you to have access to links and resources with additional information on each law and policy change. Now, there are going to be ways for you to communicate with us this morning. Many of you have already found the chat pod, which we appreciate. This is going to be the best way for you to let us know what you need this morning. If you have a comment or you have a question, you can be sure and put that into the chat pod. There are options at the top left that lets you send a message to everyone or just the hosts. That would be myself, Philip, and Rick. And we will be happy to make sure and keep track of those messages. Or if you want to send one to an individual, you can do that as well. This is the primary way you're going to be communicating with us today, as your microphones are muted. This box does move fast. There are so many of you here in the room today, which we are thrilled about, but it means it'll scroll by pretty fast for you, so you may want to keep an eye on it. But don't worry, we are keeping a very close eye on it, so we'll be keeping track of any and all questions you all might ask. Now, about questions, you might be asking yourself, how do we ask those questions? And I would say that is a great question. Thank you for asking it. We will be capturing your questions via the chat box. There will not be likely time today for us to really address those in the webinar. However, there will be a follow-up document that will answer questions that come up. So ask those questions. Put them in the chat pod. I guarantee you, if you are wondering about something, someone else in this virtual room is wondering about something similar or tangential to it. Once the document is created, it'll be emailed to all the registered participants and be posted with the webinar recording. And that webinar recording will be available on NCSW Learn. So you'll be able to look at it anytime you like, or if folks haven't been able to register or attend today because life sometimes gets in the way, you'll be able to see that under Watch Recorded Webinars in the section on NCSW Learn. So we encourage you to take advantage of that and share the knowledge you're going to get today. Now, there's some other icons that you can use to get our attention. The chat pod is always going to be the best way, especially for significant questions. But there's another one. If you look at the very top of your screen, you're going to see a series of icons. And on the far right-hand side, you're going to see a hand-raised icon. If you click the drop down next to it, you'll see a series of options. One is raise your hand. Another is agree or disagree, applaud, laugh. Laughing is always good, especially when wonderful uncle jokes are told. Speak louder. That's not one that's ever happened when I'm presenting, but that is an option. Speak softer. That could happen. Speed up or slow down. If you need us to do that, please, by all means, take advantage of those icons. It is a great way to get our attention and let us know. So, with that having been said and getting that out of the way, I would like to again welcome you to today's webinar. My name is Evan Friedel, and I'm with the Family and Children's Resource Program of the UNC School of Social Work, and I will be today's moderator. We will have technical help behind the scenes from our colleagues at FCRP, Philip Armfield and Rick Zeckman. And now I would like to ask and invite our presenters to introduce themselves to you. They are the stars of today's show. And first up, we have Tracey Brrenneman.
Good morning. How are you, Evan? Good to hear your voice again. I'm happy to be here this morning. I'm Tracey Brrenneman, and I am a CQI ITA Trainer, which stands for Continuous Quality Improvement Intensive Technical Assistance Trainer, and I'm happy to be back with the division in that role.
Thank you, Tracey, and I know that the division is thrilled to have you back, and I am thrilled to see you again, having spent a lot of time with you over the years, so welcome. Next on our hit parade of stars is Nora Carter. So Nora, I will turn the mic over to you and invite you to introduce yourself, please.
Good morning, and thank you, everybody, for being here today. My name is Nora Chambers Carter, and I serve as the curriculum developer, trainer, and contract support. Glad to have you all here today.
Welcome, Nora, and we are thrilled to have you here with us as well, and it's good to get to see you again. And last but certainly not least is Peter West. And Peter, I will turn the mic over to you and ask you to introduce yourself, please.
Thank you, Evan, and good morning, everyone. It's good to be back with the division. I currently serve as Section Chief for County Operations, and one of those operations is staff development, which has been responsible for putting this particular webinar together. So it's good to be back. It's good to see some familiar names here with us today, and we will work our way through as we hopefully don't have to endure too many uncle jokes from Evan this morning. So it's good to be back, and thank you, Oz, for joining us this morning.
Well, I'll do my best to hold back, Peter. Poor Peter has had to suffer with me the most of, I think, all the people from all my time in the division. So I'll try and take a little bit of pity on him at the very least. But we are thrilled to have all three of you here today as presenters and getting to share some of the wonderful accrued knowledge you've got for us. So thank you all for being here, and thank all of you again for signing up and being here for the webinar. Couldn't do this hard work out in the field without you. So we are going to jump right in, and we are going to start with Peter by going over some safety and prevention legislative updates. So Peter, I am turning it all over to you.
Thank you, Evan. And yes, Evan and I have endured each other for quite some time, and that's probably why we don't work together much anymore. But it is good to be here this morning. Let me just give you some pointers as we go through today. We're not going to deep dive into a lot. The purpose of today, as Evan said, is to give you a high-level overview of what's taken place in the last year and to give you the place to go find them. And I just encourage that you mark those down so that you'll know once this webinar is over, where's the link you can go, whether it's in policy, statute, a webinar, or other resources to help you find these. First couple of things we want to hit on, in Session Law 2021-100, they made revisions to the Juvenile Code that were recommended by CIP. And so one of those had to do with relative definitions. It actually was a lot more streamlined than it used to be. It also talked about how we work with parents and recommendations we make to the court around parents, especially those who are involved with medication-assisted treatment. And trying to work with them alongside of their treatment providers and not using that as something to hold against a parent as they're working through. Okay. Also, Session Law 2021-132 gave us new definitions around neglect because the purpose here was to expedite child safety and permanency. So there was some neglect definitions that were clarified in there. Also, clarified specifically who can access confidential records. Many times you get requests from people in your community. It could be a legislator, it could be a school person, who can actually access those records. And so there's some clarification there and steps that you can follow about how to make those records available. It also streamlined and clarified the RIL notification specifically around human trafficking. And if you do substantiate and you have a perpetrator, but that person is part of human trafficking, there's directive there about how you actually can or cannot notify those persons. There's also information there about diligent efforts to locate relatives. I think we would all agree this is something we haven't done well over the years. And so now it's been put into statute that we must make and document and present to the court what those diligent efforts are. And so those two, again, these were some of the things that they did. Just an update real quick about Session Law 2021-132. It did authorize a state operational CPS hotline, and so that planning has begun. More will be coming about that moving forward, all right? So where do you find more information about these specific updates? This is a live link. You should be able to click on your screen there and actually access that webinar that took place. It sits on the YouTube channel. And there's also one that sits on the DSS DJJ partnership, that webinar that was put together between the two of them that UNC did for us as well. So you can click both of those links and you can watch those webinars. And they also, the policy update one also should have some written information there for you. Okay. Now I'm going to turn it over to Nora Carter as she will discuss disaster planning requirements that changed this past year.
Thank you, Peter. Let's go over the expectations of county child welfare agencies with regards to disaster planning. Typically, counties have a countywide disaster plan that is developed by the County Emergency Management Department. This plan includes all county departments, including Human and Social Services. You may have a county child welfare plan now that is part of this larger agency emergency preparedness plan. You can review your agency's plan with the things we addressed today to ensure it complies with all the requirements that are specified in federal law. Please make note of anything that comes to you as we go through it so you can have this for further work later. The federal components of all child welfare disaster plans are listed here as a refresher, 1 through 5. Take a moment to read and familiarize yourself again with these requirements. Next, let's talk more about the federal requirements for child welfare plans. These areas are included within a provided template located on the NCDSS website in the hope this will aid you in ensuring that your county child welfare agency's disaster plan meets all the required components. Along with a copy of your child welfare specific plan, county child welfare agencies are required to submit a 2-page summary checklist of your disaster plan to North Carolina DSS. This is to assure that the child welfare requirements are completed. The North Carolina DSS website provides county child welfare agencies with a template checklist to aid the county in assuring that all required components are included. This includes the point of contacts for the development and updates to the plan, types of disasters addressed within it, when it was distributed to staff and partners, the number of staff that have completed personal family plans. We encourage county child welfare staff to complete personal family disaster plans and the agency to maintain a list of those who have completed their family disaster plan. This should include important contact numbers and special needs of the family. Also, the summary includes assurances that county child welfare agencies have a plan to support staff before, during, and after the disaster. The checklist also includes a few trauma-informed strategies as well. The state plan for expectations surrounding disaster preparedness can be found within the Child Welfare Manual section of North Carolina DSS. Within the same section, the disaster preparedness resources, you will find the toolkit or checklist that can also be used as a guide. Lastly, this link will guide you to the North Carolina DHHS webinar entitled Disaster Plan Requirements and Resources for North Carolina's Local Child Welfare Agencies. Now back to Peter.
So let's talk some now about 4B2, which is family reunification funding. There were some changes made this past year, and just to update you on what they're about. So first thing to understand is that 4B2 funding can be utilized by the county in two different ways. If county staff are doing reunification work, they can code that on their day sheets, right? If you have contracted services, someone is helping you with transportation or someone's helping you with supervision of visitation, anything like that, or other services that may be provided to the parents during that time. Those are contracted services that you would actually bill on your 1571, all right? So there's two ways that the county can bill for those services. All right. So who is eligible? And this question comes up a lot. Any child that is in foster care that has a plan of reunification age 0 to 17. So obviously 18 to 21 would not apply. But any child who is in foster care, if their plan goal of reunification, all right, need to make sure that the services for individual clients are open on the 5027 to be able to fully put those on day sheets especially. All right. So here's how it works. North Carolina allocates 4B2 family reunification funds to all 100 county child welfare agencies to provide reunification services for children in foster care and their families. Right? There is a formula, so the funding allocation for each county is determined first. There's a base of $5,000 given to each county. In addition to that, a percentage of the remaining funds available based on the average number of children in out-of-home care at each quarter's end for the previous fiscal year. All right. So here's where things got a little different this year. We're actually doing a lot of monitoring over the last 3 years. So now 4B2 cases, those family reunification cases where you're actually spending that money, are being monitored on a 3-year cycle. If you have a case that's pulled or if your county is up for that monitoring, you'll be contacted approximately 30 to 45 days in advance of the scheduled monitoring. All right. You'll also be provided with a random sample of cases, much like we do with 4E audits that come up. Okay. So to get yourself ready, there are some documents that you need to be able to provide. This is much like what we do with the 4E folder that we ask folks to keep for 4E monitoring when the time comes, or if we do a 4E review. Here's some of the documents you'd want to keep if you're utilizing family reunification services. You need to have that initial removal order or a VPA if applicable. All right. There also should be a permanency planning order for a child home visit or returns custody to a parent. And that's important because you can still use some of those services if you're in a child home visit. All right. Now, you also need to include that family services agreement that outlines what are the services, who's providing them, who's going to making sure that they're okay. You also need to be, along with that placement log for the child while they're in care. Also need the 5027 showing that you've opened code 120 and or 333 is open if 333 is applicable. Okay. You also need to be able to present the administrative cost report from your 1571. That's something you should be able to get from your business officer. But again, this needs to be submitted when they come in for review. All right. So a couple of things that they look at. If the agency billed NCDSS, the division, for Part 1 salaries for administrative cost reports, you'll need day sheets with code 24 and 120 for social workers and 333 for paraprofessionals. You're also going to have to include the narrative entry that corresponds to that appropriate day sheet. So in other words, whatever that worker is doing needs to be documented. It also needs to match what they have on their day sheets. If you build NCDSS on Part 4, which is contracted services, not your salary part, but your contracted services, you should include your general ledger, invoices that were sent to you, canceled bank checks where those payments were made, and or credit card statements for where those payments were made to that particular contractor. Okay. So if you have any questions about this, these are the two folks you'd want to get in touch with, either Wendy Cluish, she's the primary lead. Deborah Day also is her administrator. So if you have questions or if you get a notice about 4B2 monitoring coming up and you're not quite sure what to do, you haven't had one, please reach out to one of these ladies. Okay. Next, I'm going to turn it over to Tracey to talk some about some safety networks and safety circles.
All right. Of course, safety is paramount to everything that we do. So we want to talk about, what we can do to make our children and families safer. Those of us who've been around for a long time know that we used to be very much in the business of telling families what to do. Fortunately, we have been enlightened, and we know that our greater calling is to help our families identify their strengths and empower them so that we aren't involved any longer than is necessary. One way to do that is to help families add to their protective factors through safety networks. And if you haven't heard that term before, you may be saying, what is that? That is a group of individuals that provide ongoing support and services to the family to keep children safe once we're out of the picture. That network can consist of family, friends, and other community professionals that, of course, have a connection with the child and family that are willing to engage with child welfare. They certainly need to understand that there have been some safety concerns, and they're also willing to do something that provides support to the family and continues to keep the child safe. The purpose being to help our families, because again, we want our family voice to be in the forefront. Think about people in their lives that they want to support them, that they feel a connection to, so that there is a safe environment for their children. These folks are going to work together in partnership to help them build and follow a safety plan that's going to assure safety while we're involved and beyond. And then also will ensure that if it's necessary, that a child would be placed with relatives if it was safe, if it's safe and appropriate. These networks are important because our involvement with families is supposed to be temporary as possible. Those twice-a-month visits that social workers can make are just not enough to ensure safety for children, especially when we're talking about our higher risk cases. So these safety networks can help agencies enhance the family's safety. And families often have people involved in the care of their children anyway. So empowering them to reach out and involve these people even more as part of their network is going to support permanency sooner, we hope, and well-being going forward for families and children. So let's talk about how safety circles can help. Safety circles must be used during the assessment phase to build the family's safety network. So what is a safety circle? Well, this is a visual tool that social workers can use with the family to help them identify who those people would be that would be a part of their safety network, and also opens the door to talk about what the concerns are and how everyone can play a part in building those protective factors for families. The worker uses the safety circle tool, which is in the policy manual, to ask about relatives that the family currently has contact with, helps them find relatives and helps the worker find relatives to identify for the safety network. And there are 3 questions involved in that process. Who knows everything about what we're worried about here? Who knows some things? And then who knows nothing about it but should and could possibly be an important part of that safety network. Workers need to document as much information as provided by the family, including which ones would be contacted as collaterals. So you can refer to using safety circles to create safety networks with families in the Child Welfare Resources section of the manual. And here's the hyperlink for that additional information. Now, Peter's going to go over some information about the 4E candidacy definition and administrative claiming.
Thank you, Tracy. So I kind of feel limited in this because the original 4E guru is in the room with us. So please forgive me if I stumble over this, because not quite sure I could do it as good as Evan Fidel. All right. But let's give you some updates about 4E and what's going on. Just as a reminder, 4E was created in 1980 as part of the Social Security Act, right? What it is, it's an uncapped reimbursement of a portion of costs that are expended for care and allowable services provided to eligible children, all right? And so North Carolina, just like every other state, is required to develop a plan based on federal requirements and update as they change. In other words, how will we plan to spend that money? How will we use candidacy definitions? How will we make sure that it's being spent appropriately and on the right services for the right children who are eligible? All right. So the newest law changes, or the newest changes, especially around 4E, the primary one is FFPSA, the Families First Prevention Services Act. It was originally passed in February of 2018, all right? And again, you hear the name Families First Prevention Services Act. The goal being that more resources are put into the front end of a case, possibly during assessments, but especially during in-home, to ensure that a child is able to stay in their home as safely as they possibly can. And so one of the primary changes that we see along that, we're going to talk about candidacy definition in just a moment, but one of the primary changes that focused on 4E reimbursement was for children who are in group home settings. And if you remember, after we set that drop-dead deadline of October 1st of last year, or 2 years ago, after that drop-dead date, kids could only stay in a group home setting for 2 weeks and still draw down 4E fundings moving forward. Okay, now the division has taken some steps to be able to help bridge some of that gap as we move into FFPSA full implementation. All right. Now, as a result, when FFPSA was passed, we also took the opportunity to review our 4E plan, and some updates were made in the plan as well as associated policy with those. All right. One of the primary things that changed is the Title 4E definition. In other words, the candidate for foster care. People ask this all the time. Who is at risk? A child and please hear what all this says, a child at imminent or serious risk of removal from the home into foster care as evidenced by the county child welfare agencies making efforts to either prevent removal or they're pursuing removal. All right. Please hear what that says. A child is at imminent or serious risk of removal. All right. They may be at risk for other things. The safety assessment may be pretty concerning. Risk assessment potentially may be high, but are they at risk of removal from their home? All right. The addition to that is especially evidenced by the county's agencies making efforts to prevent. In other words, what have we put on that case plan? What services are we providing to the family that will prevent removal? And all that has to be well documented. Case plan is the place you want to do that. So again, make sure you see the definition that if they're at serious risk for removal and you're going to draw down $40, you need to make sure that case plan is 100% clear. What are the services and how are they preventing removal of that child? Right? And again, it fully affects and solely affects in-home services. Right? Now, you can provide in-home services to children who are not candidates. In other words, if you are moving an in-home case and they're initially a 4E candidate because they were at risk for removal, but services that are provided, interventions with the family are successful, and the child is no longer at risk for removal, you've got to code to something else, because once they are no longer at risk for removal, you have to stop coding to 4E. There are alternative program codes that you can use. You can check the CPS funding manual to find that out. Okay. The appendix in there also has revised instructions on coding options that you can use for in-home services under 215. Okay, there have been a couple of webinars that were done, but the primary one that you'd want to go back and look at are policy changes, the candidacy definition, administrative claiming for in-home services. The slides are also included with that. So I encourage you, if you have additional questions or you just need that refresher, go back and watch that webinar, pull those handouts out, use those as sort of your guide moving forward as you're working to claim 4E. Okay. Now, Tracey, Nora, and myself, over the next little bit, will address some components of changes to permanency planning policy, and Tracey will kick us off.
Thank you, Peter. So I'm going to review some of the legislative changes made in 2021 that impacted child welfare policy changes in 2022. Several changes occurred last state fiscal year in our policy manuals related to permanency. And it's going to be, again, as Peter said, a brief high-level overview on each topic, and we'll also provide more links for these and recordings of the policy to practice office hours, which here is the link to the permanency, that's a lot of P's, permanency policy to practice office hours recording. And hopefully that will be a good link. I know someone said, there we go, the Safety Circles link wasn't working, but Rick has put that in the chat, the correct one. So I'll start by talking about Senate Bill 693, Session Law 132, for those who like to see it in person. And you can always review the legislation by pulling up the law as part of this bill. There's a new definition of relative that Peter mentioned earlier, which is currently in the Cross-Function and Permanency Planning Manual, and we're going to review that in just a moment. The legislation also discusses that while in non-secure custody, the Department of Social Services must use due diligence to identify and notify adult relatives and other persons with legal custody of a sibling of the juvenile within 30 days after the initial order of removing custody. The department is required to file that information with the court regarding the attempts made to identify and notify adult relatives of the juvenile and those persons with legal custody. And if the court does not place the juvenile with the relative, the court may consider whether an appropriate former foster parent or other non-relative kin is willing and able to provide proper care and supervision. And this 30-day window is just so important that we, are making those efforts in those early days, not only to get children to permanency, but it really helps in terms of your case process and the time that social workers spend working on cases. So effective October 1st, 2021, a new definition of relative was placed in legislation. The definition and related policy can be found on pages 14 through 16 and 37 through 41 of the Permanency Planning Manual, as well as page 218 of the Cross-Function Manual. Relative is now defined as an individual directly related to the juvenile by blood, marriage, or adoption. This includes but is not limited to the following, which is grandparents, siblings, aunts, and uncles. So just remember, includes but is not limited to. One question that we've received that I would like to address here is the following. Is a putative father considered a relative? Well, like many things in child welfare, this will depend. If a putative father is not married to the biological parent, and there's not been a blood test to confirm that he is related, he's not on the birth certificate and has not otherwise been judicially determined to be the father, then at that moment he is not considered a relative. But again, we need to make those efforts to establish paternity to clarify that. Adoptive parents of siblings are not considered relatives of the legal child. However, they must be considered in the identification and notification of individuals who have legal custody of a sibling. And of course, we know how important those sibling connections are and would definitely want to explore that for those reasons as well. So now that we have the definition of a relative, what is that going to look like? Well, county child welfare agencies must identify and notify all adult relatives and other persons with legal custody within that 30-day window. This does include relatives and kin provided by the parent, but it's also people that you guys find out about in the course of working with the family. You should inform parents of the requirement to notify relatives beyond those that they have identified. And keep in mind, those parents may be able to provide necessary background information or a history of the relatives to assist in determining whether they're suitable placements or not. In situations involving family domestic violence, it may not be appropriate to notify such relatives if it's deemed that it would pose a risk to the child or caretaker. But of course, that needs to be carefully assessed. Please note that while this is a requirement to identify and notify relatives within 30 days, diligent efforts are required throughout the life of the case as new information is provided. So it's not just a one and done. County child welfare agencies have to provide documentation of those efforts to the court. More information about what is meant by diligent efforts can be found in the cross-function section of the Child Welfare Manual. So after utilizing technology or engaging the removal parents or caregivers and collaterals to seek a relative placement, what are you required to do as part of those notification requirements? Well, when informing relatives, you must notify them that the child has been removed from the custody of the parents and the options under federal, state, and local law to participate in the care and placement of the child. You must also disclose the options that may be lost by failing to respond to the notice, any requirements to become a family foster home, and the services and supports that are available for children in a foster home. If your county has elected to participate in kinship guardianship assistance payments, then that information should also be included. Local child welfare agencies may choose how to notify relatives. However, it must include that minimum criteria listed on this slide to ensure compliance. There is a relative notification letter, which is the DSS 5317 or 5317, as well as a relative interest form, the DSS 5316, that can be utilized and found on the DHHS forms website. So placement with non-relative kin does include former appropriate foster parents, and that must be considered after all relatives and any legal custodians of a sibling have been excluded. So again, that exclusion, talks about whether those relatives not only are available, but whether they're appropriate. And if they have been excluded, then the non-relative kin must be considered. If the home is assessed to be appropriate, placement must be approved by the court and designated in the court order. So you can find more details on the relative and non-relative definitions at this YouTube channel or new YouTube video for the Policy to Practice Office Hours presentation. Okay. So continuing on, this section of the law addresses requirements that must occur prior to unsupervised visitation, as well as requirements for visitation with parents who might have had a positive drug screen results. And this is what Peter had referenced earlier. This section can be found on pages 82 and 83 of the Permanency Planning Manual. And this might sound a little familiar because this is like the Rylands Law requirements that we already have in place for trial home placement. Before you can recommend to the court that children have unsupervised visitation, you must observe the parent from which the child was removed for a minimum of 2 visits. And keep in mind, minimum, it is at least 2, but you may need to do more, but a minimum of 2. Those visits must not occur more than 30 days prior to the scheduled permanency planning hearing where you're going to be recommending those unsupervised visits. And they have to be at least 1 hour in duration and held at least 7 days apart. Observations that you make during these visits must be documented and provided to the court and must support a recommendation for unsupervised visitation to the removal parent, guardian, custodian, or caretaker. Again, to assure that it's safe for the child to be with that parent unsupervised. This policy that I'm speaking about now is on pages 84 and 85 of the Permanency Planning Manual. And this has been kind of a hot topic over the years about visitation when parents have a positive drug screen. There's been a lot of opinions about whether that's appropriate or not. And so that has been addressed. The agency must not, must not withhold or cease court-ordered visitation based on a parent's substance use or positive drug screen alone. So that cannot be the only reason for ceasing visitation. During the time that visitation occurs, you would be assessing if that parent is under the influence of drugs or alcohol and is exhibiting behavior that might make the environment unsafe for the child, or they appear actively impaired during that visitation. And if you do make a decision to cancel a visit because of those factors, it can only be that visit. You can't cancel for all future based on one incident. Changes in the visitation plan as a result of a parent's substance use must not be changed unless there is an unsafe environment for the child. So just like all of our assessment of substance use, we need to be able to show the impact that their substance use is having on the child. The agency must file a motion for review and request that a hearing be scheduled within 30 days when a parent with unsupervised visitation has a positive result from a drug screen. While that motion is pending, the director may temporarily impose supervision requirements to all or part of the visitation plan. The director must promptly communicate the limited and temporary change in the visitation plan to all affected parties until that hearing. For more details on policy related to these visitation requirements, you can go to the Policy to Practice office hours presentation at the link here. And now, Nora is going to go over additional requirements within Session Law 132.
Thank you so much, Tracey. The North Carolina General Assembly passed Senate Bill 207, which became effective in December 2021. The Deer County Director Letter was distributed in May 2022, and its purpose was to discuss Senate Bill 207 changes to statute and policy. The particular DCDL that accompanies this slide is CWS 29/2022. Subject: working with juveniles impacted by child welfare and juvenile justice webinar. This statute has a number of changes that impact child welfare and the interactions with juvenile justice. Senate Bill 207 includes the new addition to the neglect definition that directly impacts intake screening in child welfare. The remainder of the statute primarily impacts juvenile justice systems and services, but include requirements to the Child Welfare Agency to participate in the juvenile and family teams meeting and the care review teams process when the family is involved with child welfare. This support includes an appropriate mental health assessment for juveniles who have been adjudicated delinquent and those who may present with various special needs. The care team will be convened by the Juvenile Justice Section of the Division of Adult Correction and the Juvenile Justice of the Department of Public Safety. If a care team is assigned to a case by the court, the care review team shall develop a recommendation plan for appropriate services and resources that address the identified needs of the juvenile. The court will then review the recommendation plan when determining the juvenile's disposition. At a minimum, the persons listed here make up the juvenile's care review team. And you see those here, 1 through 5. If the juvenile does not have health insurance for the recommended treatment, the court may conduct a hearing to determine who should pay the cost of the assessment or treatment. In some cases, the court may order the county to arrange for evaluation or treatment of the juvenile and to pay for the cost of the evaluation or treatment. For additional information, here you will find a webinar from May 2022 titled Juvenile Consultation Meetings and Care Review Team with the Department of Juvenile Justice. Peter, thank you.
All right. Let's also look at some other changes that were made as a result of Senate Bill 693. The first one being that rapid response policy, right? Just to let you know, this can be found on pages 45 through 48 of the Permanency Planning Manual. And this deals with juveniles who have to go to the emergency department for mental health treatment. And we all recognize this is becoming a significant issue. So what we recognize is that the rapid response policy says this: if they have to go to emergency health department, certain steps must be taken, right? The director or someone from the agency must contact the LME MCO or prepaid health plan within 24 hours, all right, of the determination that juveniles should not remain at the hospital. In other words, when the hospital says they're ready to go, LME MCO should be contacted right away, especially if no appropriate placement is available, all right? Also, an assessment should be performed by either the juvenile's clinical home provider, the hospital if able or willing, or other qualified licensed clinician within 5 business days following notification from the director. Okay, the LME MCO or prepaid health plan must, when applicable or required by their contract, arrange for this assessment. So we're looking at here genuinely pushing the partnership between the local agency and the LME MCO, and that needs to happen very quickly when a child is admitted to the hospital or is taken for an assessment. It must happen quickly, and that relationship, the working relationship between those two, needs to start fast. Okay, a couple of other things. So after the assessment has been completed, some other steps have to occur. All right. If the CCA recommends traditional foster home or level 1 group home, the director should identify and provide placement within 5 business days and transport the juvenile. If the CCA recommends a level of care that requires prior authorization, the LME or the MCO or their prepaid health plan, they should authorize an appropriate level of care within 5 business days. Once it's been authorized, providers have been identified, the director must place the juvenile in the appropriate placement within 5 business days, giving us some time frames, again, understanding these need to take place quickly, right? If the director or the LME MCO is unable to identify an appropriate available placement for the juvenile, or if the assessment recommendations differ, the director must immediately notify that rapid response team that was set up as a result of 7B302. All right. The director at that point can say to the response team, here's the details that you need. It is confidential information, but this statute gives the director through the designee the ability to offer to the response team, here's the juvenile's needs. Here's what their CCA has to say. Here's the behaviors that we're seeing. Here are the places that we've tried to contact. Here's the history of this juvenile, so that the rapid response team can begin to work on that. All right. In that being said, it doesn't relieve the county social services from carrying out their responsibility. Ongoing case management needs to continue, especially around educational needs. Social needs must continue to be met if the juvenile is staying in the hospital. Right? Case management can occur virtually or in person as long as the juvenile's needs are met. Okay. This one was also part of the policy to practice office hours. You can find that at the link here for this YouTube channel. And let me just throw in a plug for the policy to practice office hours. If you've not participated in those, I'd encourage you to do so. There's some great topics there. And also when you look at this YouTube channel that is set up for those, all of the policy to practice presentations that have taken place are archived there, and you can see what the subjects are to find out additional information on a variety of topics. Okay. Here's a really important one, and this one's kind of near and dear to me because I did a lot of work early on in home and in foster care when I was field staff in the county. It has to do with court requirements for 17-year-olds, in other words, getting ready to age out, but also that termination process for 18 to 21 agreement. That's brought up a lot of questions over the last several years as this program has grown, and we are certainly encouraging counties to continue to grow the 18 to 21. So there are some requirements that have to be presented to the court once the juvenile turns 18, and once the juvenile turns 17, right? And these things have to be presented consistently to the court in that last year before they turn 18, all right? Some of those things are, and again, this policy can be found on page 162 of the Permanency Planning Manual, right? So you need to report to the court what efforts have you made to identify and help find placement with the juvenile when they turn 18. In other words, or what kind of planning are you doing? Who are they going to be staying with? Who can keep them? Can they afford that? Is 18 to 21 an option so they can continue maybe potentially to reside in a placement that they're in, all right? Also, you need to report to the court, who are those adults that serve as resources for the young person when that young person turns 18, right? So that we're not just dropping them and putting them at the front door and shutting the door. Who are the people, part of what Tracey was talking about earlier, that safety circle? Who are the people around this young person as they turn 18 that will still continue to be there? If they choose not to be in the 18 to 21 program, are we helping them build that safety net of people around them so that they've got people that they can lean on consistently, all right? Also, the contact information of the person responsible for overseeing foster care placements, with young adults in the county, all right? Who is this person responsible for making sure that that happens, all right? So please keep these in mind, especially as you've got those teenagers getting ready to age out. A lot of work that we need to do to get them prepared, all right? Other things that we need to be reporting to the court, if it's appropriate, if the young person has information about how they may maintain contact with their siblings, parents, or relatives, all right? How are they going to do that? What do they want to do? Have you given them the information? Do they know where their siblings are placed, right? Have they been able to, do they know where their parents are? Do they know who other relatives are? Again, it goes back to who are those resource people, right? Have you provided the young person with a point of contact for Medicaid? Again, if they choose not to be in 18 to 21, we need to make sure their Medicaid continues. Have you maintained physical and mental health services so that when they turn 18, there's a continuity of service taking place, right? You've also got to report to the court, have you provided the young person with the information about educational, vocational, job plans? Have you had those conversations? You know, as a part of their links work, have they talked about what they want to do when they get out of high school? Are they going on for higher education? Are they getting into a trade? You need to report to the court. Here's how we have helped this young person get to a better place so that when they turn 18, there is some level and ability to be independent. Okay. You've also got to report to the court. Have you given them the documents that they need in order to just survive? Copy of their birth certificate, copy of their social security card, health insurance information, which may include Medicaid. Do they have a copy of their driver's license or other identification card? Do they have copies of or access to educational and medical records? And have you also provided them information about how they can participate in foster care 18 to 21? Again, necessary things. Yeah, they're a checklist you got to give to the court, but you're also preparing a 17-year-old to be 18. You're preparing them to be independent if that is the choice that they make. Okay. That being said, if they choose to be a part of the 18 to 21 program, everyone recognizes the agreement must be signed. All right. Where are they going to be staying? What is their plan? Are they going to work? Are they going to school? What are they moving towards? All right. But the question consistently comes up, how do we terminate that program? Because there are times when it's appropriate to terminate the 18 to 21 program. All right. So this can also be found on page 173 of our permanency planning manual. All right. So if the young person elects to terminate the 18 to 21 program, the process can move forward. They can notify you verbally or in writing. All right. The agency should document in their case record the method in which the young adult terminates the agreement. It may be, and I've seen this happen, they may just call you up and say, I don't want to do this anymore. I'm doing this instead. All right. That could potentially be the way that they terminate their agreement. Hopefully as a practice thing, you might give them some time to think about it. All right. But if that's what they say and they consistently say it, then we need to honor that and let them move forward. However, if the agency, for whatever reason, decides that they would like to terminate the agreement and the young person disagrees, please hear that. That's pretty clear in the policy. When the county, if you want to terminate the agreement and the young person disagrees with that, all right, we can't just walk away at that point. The agency should file a motion for review, because remember, these cases also have to be reviewed by the court. So a motion for review should be filed with the court so that a resolution can be reached, right? Now, what is not in statute and what's not in policy is the criteria for what the court should consider when resolving whether or not to terminate. So basically what's going to happen is you're going to file a motion. Both of you will be in court making your case to either to terminate, the young person making their case to not terminate, and the court gets to decide primarily based on best interest of that 18 to 21-year-old as they're wanting to continue potentially in the program. Okay. Just keep that in mind. If the young person wants to terminate, they can do so and it can end. If the county wants to terminate and the young person disagrees, that has to go before the court. Okay. Again, policy to practice office hours presentation was done about those requirements for the 17-year-olds as they get ready to turn 18 and the termination process. The link is there for you to go view. And again, putting in a plug for all those presentations, a lot of good information there on that YouTube channel. Okay. So Evan, I will turn it back over to you.
All right. Thank you very much, all of you, for all of that wonderful information you have been able to provide us. And we realize for many of you, this came fast and furious. So a couple of things. First of all, we want to remind you is this will be recorded and you will be able to see it again at your leisure. But equally, as this has come at you, we realize that there may be questions. So we want to make sure that you take a moment now and type those questions into the chat pod. We don't have time, unfortunately, today to respond directly right this minute. However, all the questions that are being asked are going to be gathered, will be answered, and those answers will be put together into a document. That follow-up document will be emailed to all the registered participants as well as being posted with the recording of this webinar. So while we start closing ourselves out, please make sure you type those questions in, and we'll make sure that we keep the room open for a few minutes after we're finished to give you guys a chance to get those questions typed. For those of you who might be a little bit slower on the type, I certainly am a hunt and pecker myself, so we want to give you guys that opportunity. I also want to share with you some of the contact information for our three wonderful presenters today, Tracey, Nora, and Peter. You will see on the slide in front of you if you would like to reach out to them to ask them more specific questions or hear more about what they do and how they do it and how it affects the work you do. By all means, please take advantage of those emails and reach out. And so I'll leave this up for just a moment so you can either cut and paste it out of the link or so you can write it down. And then I will let you know how you can save this time today as training credit, because I know for a lot of you, you want to make sure that you get credit in the training system for the time you have spent with us today. So I'll pause just for a moment for you all to copy those emails, get some questions in, and then we'll move into that last little bit of what we need to cover today.